No pockets in here. Nothing up in your bra. It's good.
What happens when the person whose job is to enforce the law becomes the one breaking it? Today, we are doing a full legal breakdown of a real case, the DUI arrest of Shelby Alyse Coniglio, a Pinellas County Deputy Sheriff in Florida, who was pulled over by a fellow officer in the early hours of May 17, 2022. Her blood alcohol content was nearly 3 times the legal limit. She tried to use her badge to avoid consequences. It did not work. By the end of this video, you will understand exactly what happened, every law that applied, what her legal options were, what she ultimately chose, and what lessons every driver and every public servant should take from this case. Let's get into it. At approximately 1:03 in the morning on May 17, 2022, St. Petersburg police officer Kristin Higgins conducted a traffic stop at 108th Avenue North and 4th Street North in St. Petersburg, Florida. The driver was 26-year-old Shelby Alyse Coniglio, an off-duty Pinellas County Deputy Sheriff who had been employed with the Sheriff's Office since September 10, 2018, working in the Patrol Operations Bureau. According to police, Officer Higgins observed several signs of impairment during the stop. Coniglio had an odor of alcohol on her breath, she had slurred speech, she had a blank expression, her eyes were bloodshot and glassy, and she was unsteady on her feet. Now here's where it gets interesting. Coniglio reportedly offered 3 explanations for her condition. First, she identified herself as a deputy sheriff. Second, she claimed she had been assembling furniture, presumably suggesting her physical unsteadiness had another cause. And third, she said she was wearing contact lenses, apparently as an explanation for her bloodshot, glassy eyes. None of those explanations were enough. Coniglio agreed to participate in standardized field sobriety tests, but she performed poorly on them. Officers then asked her to submit to a breath alcohol test. The results came back at 0.206% on the first test and 0.219% on the second test. To put that in context, the legal limit in Florida, and in every state in the United States, is 0.08%. Coniglio's BAC was more than 2.5 times the legal limit. In fact, at 0.206, she was more than 2.5 times over the limit. At 0.219, nearly 2.75 times over. She was arrested and charged with 1 count of DUI with a blood alcohol level of 0.15 or greater, which, as we will explain, is an aggravated form of DUI under Florida law. She was transported to the Pinellas County Jail without incident. She was released on her own recognizance at 10:44 a.m. that same morning. And as for her job, she was immediately terminated from the Pinellas County Sheriff's Office, consistent with agency policy. Let's get into the actual law. In Florida, DUI is governed by Florida Statute Section 316.193, Section 1. This is the core statute we need to understand. Under Section 316.193, subsection 1A, a person commits the offense of DUI, driving under the influence, if they are operating or in actual physical control of a vehicle while under the influence of alcoholic beverages or any chemical substance to the extent that their normal faculties are impaired. But there is a second way to be charged. Under subsection 1B, a person also commits DUI if they are driving with a blood alcohol level or breath alcohol level of 0.08% or higher, regardless of whether their normal faculties appear impaired. This is sometimes called the per se version of DUI, meaning impairment doesn't even have to be proven separately. The number alone is enough. In Coniglio's case, prosecutors had both elements. They had clear evidence of impaired normal faculties, the slurred speech, the blank expression, the bloodshot eyes, the poor performance on field sobriety tests, and they had a breath alcohol level that was nearly 3 times the legal limit. Now, Florida law goes further. Under Section 316.193, subsection 4, the penalties increase substantially when a person's blood or breath alcohol level is 0.15 or higher. This is Florida's aggravated DUI provision. The legislature recognized that a BAC of 0.15 represents a significantly higher level of impairment and danger to the public, so they created enhanced penalties for it. Coniglio's breath alcohol content registered at 0.206 and 0.219, well above even this aggravated threshold. So she was not just facing a standard first offense DUI, she was facing an aggravated first offense DUI under Florida law. Now let's talk about what normal faculties means in Florida, because this comes up in every DUI case. Florida courts have defined normal faculties as the ability to see clearly, hear clearly, walk, talk, judge distances, drive, make judgments, and perform the many mental and physical acts of daily life. When those faculties are impaired, and the officer's observations here painted a very clear picture, the first prong of DUI is satisfied without even needing the breathalyzer number. Let's talk about the field sobriety tests, because these are critical evidence in DUI cases, and people often don't understand how they work legally. In Florida and across the country, law enforcement uses standardized field sobriety tests developed and validated by the National Highway Traffic Safety Administration, the NHTTSA. The three standard tests are the horizontal gaze nystagmus test, sometimes called the eye test, the walk and turn test, and the one-leg stand test. These tests are not pass-fail in a simple sense. Officers are trained to look for specific clues during each test. Each clue is documented and can be used as evidence of impairment. Now, Coniglio raised the contact lenses argument, suggesting her eye condition might explain bloodshot or glassy eyes. This is actually a recognized issue in DUI defense. Contact lenses can cause redness and irritation. However, bloodshot eyes from contacts typically don't explain slurred speech, unsteadiness, the odor of alcohol, or a blank expression. And it certainly doesn't explain a BAC of 0.206 and 0.219. As for the furniture assembly argument, the attempt to explain physical unsteadiness through fatigue or physical exertion, again, this is not uncommon as a defense claim, but courts look at the totality of the evidence. When combined with a breath alcohol level nearly 3 times the legal limit, these explanations carry very little weight. Coniglio's decision to perform the field sobriety tests is also worth noting. In Florida, a driver is not legally required to perform field sobriety tests. These tests are voluntary. However, refusing them does not automatically help a driver either, because officers can still observe signs of impairment and move forward with an arrest. Here's another critical piece of this case: the breathalyzer. And to understand it, you need to know Florida's Implied Consent Law, found in Florida Statute Section 316.1324. Under implied consent, any person who operates a motor vehicle in Florida is considered to have given their consent to submit to an approved chemical test, breath, blood, or urine, if a law enforcement officer lawfully arrests them for DUI and has reasonable cause to believe they were driving under the influence. In plain terms, when you get behind the wheel in Florida, you have already consented to a breathalyzer if you get arrested for DUI. It's built into your driving privilege. What happens if you refuse? Under Section 316.1324, a first refusal results in an automatic 1-year driver's license suspension. A second or subsequent refusal is a first-degree misdemeanor, meaning it carries criminal penalties in itself, separate from any DUI charge. In Coniglio's case, she submitted to the breath test, and the results were damaging: 0.206 and 0.219. 2 separate readings, taken close together, and producing consistent results. From a legal standpoint, 2 readings taken close together and producing consistent results is actually significant. It reduces the ability to argue equipment error, operator error, residual mouth alcohol, or medical conditions like GERD or diabetes that can affect results. But 2 readings within a close range of each other significantly undermines those arguments. Coniglio was charged with 1 count of DUI with a BAC of 0.15 or greater. Let's walk through exactly what penalties she was facing. Under Florida Statute 316.193 Section 4, for a first offense DUI with a BAC of 0.15 or higher, the potential penalties include a fine of not less than $1,000 and not more than $2,000. Compare that to a standard first DUI, which carries a fine of $500 to $1,000. The higher BAC doubles the minimum fine. imprisonment up to 9 months. A standard first DUI carries up to 6 months. Again, the elevated BAC adds 3 additional months of exposure. Mandatory installation of an ignition interlock device for a minimum of 6 months if convicted. A mandatory driver's license revocation of at least 180 days and up to 1 year. Mandatory completion of a substance abuse course conducted by a Florida licensed DUI program. Mandatory probation of up to 12 months. In addition, there's a possible vehicle immobilization or impoundment for 10 days. Now, Coniglio was also cited for careless driving, a separate traffic infraction under Florida Statute 316.1925. This statute provides that any person operating a vehicle on a public roadway in a careless, negligent manner, without due regard for the safety of persons or property, commits a moving traffic violation. This is a civil infraction, not a criminal charge, but it's significant because it became relevant to the eventual plea outcome. Now let's talk about something beyond the criminal charges, the professional and administrative consequences. Coniglio's employment was immediately terminated by the Pinellas County Sheriff's Office following her arrest. The Sheriff's Office stated this was consistent with agency policy. This is an important point. Law enforcement agencies in Florida and across the country typically maintain zero-tolerance policies for DUI arrests, particularly for off-duty officers, and there are very good reasons for this. Law enforcement officers are held to a higher standard. They take an oath to uphold the law. They carry the public's trust. And in Florida, the Florida Department of Law Enforcement, the FDLE, maintains oversight of law enforcement officer certification. Under Florida Statute Section 943.1395, the FDLE is authorized to revoke or suspend an officer's certification for actions that demonstrate a failure to maintain good moral character. A DUI conviction, especially one with a BAC nearly 3 times the legal limit, is the kind of conduct that can trigger revocation of certification, ending a law enforcement career permanently. In Coniglio's case, the termination happened immediately, not after a conviction, but after the arrest. This reflects the heightened standard law enforcement agencies apply to their officers. The larger message here is clear. Professional consequences and criminal consequences are separate tracks. Even if a criminal case is reduced or dismissed, administrative consequences can be, and in this case were, permanent. Now let's talk about how this case actually resolved, because this is where the legal strategy becomes very instructive. On May 23, 2022, just days after her arrest, Coniglio entered a not guilty plea, which is the standard expected move at the initial arraignment stage. Defense attorneys routinely advise clients to plead not guilty at arraignment while they evaluate the evidence and explore options. Then, on March 30, 2023, nearly a year after her arrest, the case reached its resolution. Coniglio entered 2 pleas. She pleaded guilty to the careless driving charge, and she entered a no contest plea to a reduced charge of DUI with a BAC below 0.15. Let's unpack both of those carefully. First, the no contest plea, or nolo contendere. Under Florida law, a no contest plea means the defendant does not admit guilt, but also does not contest the evidence presented. Legally, it results in a conviction the same way a guilty plea does for sentencing purposes. However, it has a specific advantage. In most civil proceedings, a no contest plea cannot be used as an admission of liability. So if anyone wanted to sue Coniglio in civil court for damages related to the DUI incident, her no contest plea could not automatically be used against her the way a guilty plea could. Second, notice what happened to the charge itself. The DUI with BAC of 0.15 was reduced to a DUI with BAC below 0.15. This is a significant reduction. As we discussed, the aggravated DUI charges carry higher fines, longer potential jail time, and mandatory ignition interlock. The reduction to a standard range first DUI meaningfully reduced her sentencing exposure. For the DUI charge, Coniglio was sentenced to 12 months of probation, attendance at DUI school, and community service. No jail time, no conviction for the aggravated DUI, a plea deal that avoided the worst outcomes. This is how plea negotiations work in the American criminal justice system. Prosecutors often offer reduced charges in exchange for a guilty or no contest plea because it avoids the cost and uncertainty of trial. Defense attorneys negotiate to protect their clients from the harshest possible outcomes. Let's address the elephant in the room. Coniglio announced she was a deputy sheriff during the stop. This is often called professional courtesy, the informal, unwritten practice where law enforcement officers might give a fellow officer a pass during a traffic stop. Did it work here? Absolutely not, and it should not have. Officer Kristin Higgins followed the law. She observed signs of impairment, she administered the tests, she made the arrest. She did her job. This is exactly how it should work. The law is not a membership card. Florida Statute 316.193 applies to everyone who operates a motor vehicle in the state, regardless of occupation, rank, or badge number. In fact, there is a strong argument that law enforcement officers should be held to a higher standard, not a lower one. They understand what impaired driving does to victims. They have seen it firsthand. The expectation that a badge should make DUI disappear is exactly the kind of conduct that erodes public trust in law enforcement. Officer Higgins deserves recognition for doing the right thing, regardless of who was sitting in that car. Let's close with the key legal lessons from this case. 1. Florida's legal limit is 0.08% and the aggravated threshold is 0.15. A BAC of 0.206 to 0.219 is not a close call. It is a case study in extreme impairment. At these levels, the science is clear. A person cannot safely operate a vehicle. 2. Florida's Implied Consent Law means that driving is a privilege, not a right, and that privilege comes with the obligation to submit to chemical testing if lawfully arrested for DUI. Refusing has its own consequences. 3. Field sobriety tests are voluntary in Florida, but declining them does not make a DUI case go away. Officers can rely on their own observations. 4. The aggravated DUI charge, carrying enhanced penalties for BAC above 0.15, was reduced through a plea agreement. This shows how important experienced legal representation is, and how the criminal justice process works through negotiation as well as trial. 5. Professional consequences can be more severe and immediate than criminal ones. Coniglio lost her career on the day of her arrest before any court ever ruled. 6. A no-contest plea is not an admission of guilt, but it carries conviction-level consequences for sentencing. It is a legal tool with specific strategic uses. 7. No badge, no title, and no personal explanation excuses dangerous driving. The law applies equally. This case is a powerful reminder that the law is not abstract. It applies to real people in real situations with real consequences for their freedom, their careers, and their communities. If you drive impaired, you are not just risking a charge under Florida Statute 316.193. You are risking your own life and the lives of everyone else on the road. If you found this legal breakdown helpful, please share it because legal education matters. Understanding your rights and the laws that govern your community is one of the most important things you can do as a citizen. I will see you in the next one.